but I don't know what you want me to do. And I cannot give you legal advice. I cannot walk you through this procedurally.
I'm not asking for legal advice. I thought
you are. I don't know that because you didn't turn in the form.
I'm going to bring it in. I'll bring it in.
Okay, but you're telling me all these things, and I'm just telling you, there's nothing else I can do. I set the date. You come down here. If I have all of the paperwork, you'll get your judgment. Then I'd swear you in, and I'd take a default today. That's what would happen. It wouldn't automatically be adjourned out. That wasn't done. So what happens is it gets a...
What you're watching here is a moment that happens in courtrooms across the country every single day. Someone walking in fully confident they did everything right, only to discover a single missing step can stop their entire case. The plaintiff clearly believes she followed the instructions when filing this lawsuit, but the judge immediately points out a procedural problem that changes everything. In civil court, paperwork isn't just paperwork. It's the foundation of the entire case. And one missing requirement can mean the difference between winning today or walking out empty-handed.
Adjourned out. Ivanov. Okay. Lauren Griffin. They are not checked in. You did not pay for the second mailing or didn't do a second mailing, so I can't take a default today for their failure to appear.
Okay, he did get it. I just never put that piece of paper back to the court. I'm sorry. He got both.
What?
He got both summons, though.
No, but there's a mailing that needs to be mailed by the court.
It was.
And no, it wasn't, because my file reflects the second mailing. There would be three services, ma'am. There would be a service that's basically a service by a person. There would be a mailing, and then there is a second mailing in order for me to proceed today with the default. That second mailing was not done.
By the court?
You did not pay for the second mailing for the court to do that.
Okay, nobody told me I had to pay for a second.
Well, I get it, but it's just not there, so I can't do anything. The best that I can do, ma'am, is to adjourn this out. I will adjourn it to my next available day, which is March 13th.
Well, can you please tell me what I have to do? Because I was not told that I had to do something else.
Not at this.
This moment is actually a perfect lesson in something called proper service of process. Before a judge can issue a default judgment, meaning the other party automatically loses for not appearing, the court must have documented proof that the defendant was notified correctly. That usually requires several steps: personal service, official mailing from the court, and sometimes even a second mailing. Without those steps, the judge legally cannot move forward, even if everyone believes the defendant already knows about the case. It might seem frustrating, but these rules exist for one major reason: protecting due process.
This point that I'm aware of, and I can't give you legal advice. I can only tell you that for me to proceed by default at the first hearing, you would have needed to do what's called a second mailing. That wasn't done. So I can't proceed with the default today.
Okay.
I'm going to adjourn it to the 13th, 2026 at 3 p.m. That's an in-person hearing. Ma'am, on this date, how much are you claiming they owe?
Okay, wait a second. Can you please go back? I do not, you have to tell me how to do this second mailing. When I went to file all this stuff, they told me what to do, and that was never part of.
They can't give you legal advice, ma'am. My clerks can't do that. So you filed the paperwork, right?
Yes.
And that's how the case gets on the docket. So from the paperwork that you filed, there was a service on the defendant, which would have, see what the service indicates. Actually, there was no service on the defendant. Did you have somebody serve them?
Yes.
Okay. That person, whoever served them, We do not have the return of service.
I know that's
That's-
my fault. He gave it to me to take to the court and I didn't do it. That's my
Okay. So that's not here.
I get
The
it.
mailing would have been done by the court. The first mailing, which was done by the court, we did that.
Yes.
If you wanted to take a default the first time around, you would have had to pay for a second mailing, which would have been done by the court. That has not been done.
Nobody told me that.
Well, ma'am, that's why people hire.
And here we see one of the most difficult realities of representing yourself in court. The judge isn't being dismissive here, he's actually following strict ethical rules. Court staff and judges cannot tell someone how to fix their case step by step, because that would be considered legal advice. They can explain what went wrong, but they can't guide someone through strategy. That leaves many self-represented litigants stuck in a tough position, trying to navigate a legal system built around procedures they may have never encountered before. So here's a question for you. Should courts provide clearer guidance for people representing themselves, or should the responsibility stay entirely with the person filing the case?
Attorneys or read the rules. I mean, I don't know my clerks can't give you legal advice.
Okay, as far as listen, I'm not trying to be argumentative. I've never done anything like this before. I've never dealt with the court. I've never had to do anything like this. I was following the instructions and I thought I did what I was supposed to do. So I would not have thought
Ma'am,
of that as legal advice.
Ma'am, the case is started. So you did that. I just can't do certain things today because other things weren't done. But that doesn't mean the case is over. It's just, it gets adjourned out to a date.
Okay, so can you just at least, who do I call or who do I get in touch with to accomplish this through the court, this second mailing? And the other problem is,
Ma'am, I don't need the second mailing now. And the reason I don't need the second mailing is because the one hearing that the tenant would get, in essence, has happened today.
yes,
Okay, so I don't need the second mailing at this point. Let me put it to you this way. If you had come in, filed the papers, the normal mailing would have been done by the court. If you had paid for the second mailing and the second mailing gets done by the court, then I'd swear you in and I'd take a default today. That's what would happen. It wouldn't automatically be adjourned out. That wasn't done. So what happens is it gets adjourned out if the tenant's not here.
okay. So now what? You said I have to do this again?
Do what again?
Come back to court?
I'm setting it for March 13th, 2026 at 3 p.m. That is an in-person hearing. You'll need to come down to the court. They'll get notification of that hearing. If they're not here at that point, I can take a default.
Okay. He moved out. I have no idea where he went. And so if that gets sent to this address, I don't know how that's going to work. And yeah, so I still want the back rent.
I understand what you're saying, ma'am, but I mean, he's going to have personal service for me to issue a money judgment, but
he got personal service. He got served. I
don't know that because you didn't turn in the form.
I'm going to bring it in. I'll bring it in.
Okay, but you're telling me all these things, and I'm just telling you, there's nothing else I can do. I set the date. You come down here. If I have all of the paperwork, you'll get your judgment. But I don't know what you want me to do, and I cannot give you legal advice. I cannot walk you through this procedurally.
I'm not asking for legal advice. I thought it was
you are
straightforward.
And so I will see you on the 13th at 3 p.m. Thank you.
Now the courtroom shifts to another case, and suddenly the entire conversation changes. Instead of procedural errors, this one centers around a landlord-tenant dispute and whether the tenant actually moved out months ago. The tenant claims she left the property 8 months earlier and even returned the key. But the landlord's attorney raises an important legal point. If personal belongings are still inside the property, the law can still consider that possession. That small detail could completely change how the court handles the case and whether rent is still legally owed.
Calls the case of Jeffrey Patrick versus Matthew Moore. Nobody's here. Neither party appeared. Case dismissed. Is that it? Thank God. Okay. Court stands.
Morning, Your Honor. Mustafa Hawili on behalf of plaintiff.
Are they here?
Not checked in.
Suzette Hampton? They are not here. Counsel, if you'd like to take a default, you've done the second service. Please raise your right hand to be sworn. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes, Judge.
All right. What is your claim in this case?
Judge, this is this is a complaint to recover possession of property with a supplement. Hold on, Your Honor. I believe Ms. Hampton is here.
I am here.
Okay, there you are. You got her. Okay.
Yes.
All right, Ms. Hampton.
Yes, sir.
All right. This is a case for termination of tenancy.
Your Honor,
What's your position on this, ma'am?
Your Honor, I moved 8 months ago.
You did what?
I moved from the property 8 months ago.
8 months ago?
Yes, sir.
You know anything about that, counsel?
Judge, yes, I did discuss this with my clients. They're not aware whether or not she has actually moved because there are still possessions that belong to her that are still on the property. You know how that works, Your Honor. The law says if she leaves anything behind, it's still considered possession under the law, so they couldn't go in there and empty it out. If she's claiming now formally that she left, Judge, then I would just ask the court recognize that and have my clients take possession so they can go into the house and empty out her stuff.
She's indicating she surrendered possession.
Okay.
So she surrendered possession. They've also filed a money claim. That's going to get a bit complicated given the fact that if she moved 8 months ago, ma'am, did you give them keys?
Yes, sir. I notified Mr. Adelman I had left the key in the mailbox. So, and we had on several occasions notified him and we got no response.
Okay. So here's what I'm going to do. I'm going to indicate that possession has been surrendered. They're still, ma'am, claiming a money judgment against you. And how much are you claiming in terms of your money judgment, counsel?
Judge, $13,455.
And how much of that is rent?
All of it.
All rent.
Correct.
How much was monthly rent?
$1,495.
So about $1,500.
Correct. And Judge, I also don't want to complicate this on the court. If you want to kick out the issue of money for a couple of weeks,
I'm going to kick it out. I'm just trying to figure out what your claim may be claiming. If she left 8 months ago, and if they were notified that she left 8 months ago, I don't know if the claim for rent's going to be a proper claim.
And you and I are on the same page, Your Honor. That's why I need to discuss it with them.
All right. So, Ms. Hampton?
Yes, sir.
What I'm going to do is I'm going to adjourn your case out. I'm going to adjourn it out a couple weeks since possession is not an issue. I'll adjourn it out to, a few weeks. Let me adjourn you to the 20th. All right, March 20th.
Thank you, Judge.
2026 at
12 noon.
At 12 noon.
Okay.
That, folks, is an in-person hearing, so you both must be present here at the courthouse.
And then, Judge Simpson, the only request is if my clients decide they want to just waive this and dismiss it, I can file a dismissal and not have to appear, correct?
If you give notification to Ms. Hampton now that she's appeared that you're no longer claiming it,
Okay,
and we'll dismiss the money claim, and she knows that, I don't have a problem with that.
no problem, Your Honor. Thank you so much.
Thank you.
Hampton, thank you.
Have a
You're
good weekend,
welcome.
everybody. Bye-bye.
Bye.
Court calls the case of Blue Heron Point versus Justin Rowland. Hi there.
No, Miss Haddad.
Good morning, Your Honor. Rania Haddad for the plaintiff. I believe that's a dismissal without prejudice.
This is a dismissal.
I believe so. I had 3
Cases-
cases. Only 2 are going, so that's not.
Blue Heron Point versus Rowland. Rowland's not here. Case is dismissed on plaintiff's motion without prejudice. Haverhill on Clark versus Amy McDonald.
Good morning, Rania Haddad, 84927 for the plaintiff.
Good morning. My name is Amy McDonald.
Hello, Ms. McDonald. All right. Why do I have possession on these files? I don't. Those are not the terms we use. Hold on one moment. Okay, what is plaintiff's claim in this case?
Your Honor, this is a complaint to recover possession of property due to lease violations, specifically lease violations that resulted in police presence. So this is a termination of tenancy, Judge.
All right, Ms. McDonald, what is your position on this?
I submitted some evidence to the court.
What you're seeing here is something judges deal with constantly. Large amounts of evidence being submitted without the other side having a chance to review it. In legal proceedings, fairness requires that both parties have access to the same information. That's called discovery and disclosure. Even if the evidence might be important, the judge can't evaluate it until both sides receive copies. That's why this hearing gets pushed to a later date. It might seem like a delay, but in reality, it's the court making sure the process remains fair and transparent.
Yes, I'm not, so that you know, I don't have a context for what to do with all of this, okay?
I'm sorry.
So that's okay. And also, I don't believe. Who this came from? Okay. So counsel, so that you're aware, I have probably, I don't know how many pages, and a flash drive and some additional documents, and it looks like another document may have come in. Okay, you didn't give a copy of any of that to the plaintiff, did you, ma'am?
I'm sorry, I did not.
Okay. Do you have copies of what you gave to the court?
Some of them, yes.
All right, here's what I'm going to need you to do. I'm going to need you to make copies of what you gave to the court. I don't know what we're going to do with the flash drive. We'll have to figure something out. What's on the flash drive, man?
A lot of things that's gone on with me since I've been a resident of Haverhill.
Okay, I'm not sure I know what that means. But
Several of-
okay.
Excuse me, Your Honor. I've been trying to say this in a way that everyone can understand. I filed several complaints at Haver Hill, which no one answered. And when I filed those complaints, I had to leave. So just to give you a little background, I've been calling.
Well, I'm not sure the background's going to do me much good at this point, because council doesn't have what's there. So you're going to need to mail to council, and I'd suggest you do it today, given the situation with our postal service, the information, copies of the information that you supplied to the court.
Yes, sir.
All right. We'll figure out what to do with the rest at the next hearing. I'll adjourn this out to March 20th, 2026 at 12 noon. That's an in-person hearing, so I'll need the parties here. And then we'll figure out what we'll do with the flash drive if one isn't sent to your account.
I'm sorry, could you was that 12 p.m.?
12 noon. Yes,
Thank
ma'am.
you.
All right.
Okay.
Thank you.
Thank you. Excuse me.
Haverhill on Clark versus, is it Salida Jackson? Alicia Jackson?
Good morning, Rania.
Jackson. Go ahead, Council Secretary.
Sorry, Judge Rania Haddad for the plaintiff.
Jackson, they are not here. If you'd like to take a default, raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, whole truth, nothing but the truth, so help you God?
I do, Judge.
All right, go ahead.
Your Honor, due to the defendant not appearing and plaintiff sending out the second mailing or requesting the second mailing, we do move for a default judgment for possession. This is a complaint to recover possession of property due to multiple lease violations, including but not limited to multiple noise complaints and threatening behavior. And as a result of that, a notice to quit was sent to the defendant. So we do move for a default judgment for possession only. And we are requesting a writ date of March 9th, 2025. To my knowledge, the defendant is not a minor, incompetent, or in the military. And to my knowledge, the property has been kept fit for its intended use and purpose, and is up to code with all local and state health and safety codes. Excuse me. It's Friday, Judge.
Judgment to the plaintiff. That is by default for possession. No redemption amount. Writ to issue in 10 days.
Thank you, Judge.
Thank you. Propel Property Management versus Caitlin, is that LaRoque?
That's correct, Judge. Your Honor, Adam Devlin, P72877 for the plaintiff.
And is Caitlin here?
Yes.
Okay, all right. I tried to make no presumptions. He answered, and but I could have been Caitlin. I didn't know. All right. Anyway, what's plaintiff's claim in this case?
Plaintiff's claim is that this is a non-payment of rent action, and after demand, there is currently due and owing $12,872.50 in rent. This is possession and.
Now, this next case introduces another issue courts face every day: unpaid rent and financial hardship. The tenant explains they applied for emergency assistance and can start making payments immediately. Instead of rushing to eviction, the judge takes time to break down the numbers, analyze the assistance program limits, and explore whether a payment plan could resolve the situation. This is where courtroom decision-making becomes more than just enforcing rules. It's about balancing legal obligations with practical solutions that might keep a family in their home while still protecting the landlord's rights.
Money, so the costs are $329.50, totaling $13,202.
All right. And Ms. LaRoque, what do you have to say about that?
We did apply for the SER assistance through DHS, and then we can pay about half of that within the next week.
All right. So let's back up a second. You can play about half of it next week, right?
Yes.
You applied for SER. Okay. How many people are in your household?
5.
5? Okay, so just so that you know, the state emergency relief with 5 individuals will only really pay about $870 if they pay anything at all. Okay, if they max you out on that. Okay, so which is not nothing, but just so that you understand, it's not going to cover a great deal of this amount. Now you said, so how much is your monthly rent?
1,400.
Okay. And how much did you say you can pay?
We could pay 6,000. We made a payment of 1,000 last night, and then we could pay another 6,000 within the next week.
Okay. Counsel, do you have the 1,000 that they paid in this figure?
No, Your Honor. I would have pulled their ledger last night. If you bear with me for 30 seconds, I can log into my client's accounting and verify their $1,000 payment. With all the fun of 2 form factor login.
These are that's fine.
Yes.
Your Honor, I do see their $1,000 payment.
Right, but the figure you gave me,
It
had not
predates
taken
that.
that off yet.
Correct.
Right.
Predates. Yes.
Okay. That's fine. All right. So
Your Honor, I'd be inclined to adjourn this for their aid to come back for another pretrial and see if I can work out a conditional dismissal with them.
okay,
Especially if they're
that's
gonna
what I
pay
was.
$6,000.
Yeah. So when, folks, when can you pay the 6,000?
Whenever, Your Honor. We've had some issues with the payment method that they've made us use. So unfortunately, we have to pay in cash using Pay Near Me, and we can only withdraw about 500 a day. So that's kind of slowed us down, but we do have the funds.
Okay. All right.
And we can make those payments within the next week.
Who are you?
I am Ryan. I'm also on.
Okay. You're on the lease also? Because the case isn't in your name, and I'm just like, why is he talking?
Sorry.
Anyway, no, okay.
I don't mean to
No,
speak.
it's okay. It's okay. As long as she's okay with you talking, that's okay. But usually if the guy starts talking, things get messed up. I'm kidding. All right. So you think you can pay the 6,000, say by Monday?
Yes.
Yes. Okay. So 6,000, I'll make that due by March 2nd. Okay. And then I'm going to adjourn this out a week. Actually, it's going to be 2 weeks because I don't have the 6th now available to me. So I'd adjourn it out to the 13th. See if you guys can work something out. All right. Let me ask you this. You're going to pay the 6th between the 2nd when you make that payment and the 13th. Is there any additional payment you can make?
Yes, Your Honor. We intend on getting fully caught up as soon as possible.
No, I got you. Do you know how much that would be?
Another 2,000.
Minimally another 2,000.
Okay, that's fair. That's fine. Okay. And I'll just say 2,000 by the 12th. Okay. Then I'll adjourn you guys out to March 13th, 2026 at 3 p.m. That's an in-person hearing, so I'll need you guys down at the courthouse, okay? If you work out, if you talk to counsel and see if you can work out what's called a conditional dismissal on that, okay? And see what we can work out. Not forcing you to do anything. If you come down to the court, we'll figure it out, but that's always an option for you, okay?
Thank you, Your Honor.
Thank you. All right. Guys, take care.
You as well.
So,
Thank you, Your Honor.
Irina Politano versus. Court does call the case of the people versus Kawanda K. Thomas.
He's joining me.
Judge. Assistant Public Defender on behalf of Ms. Thomas.
And Sherilyn Foster Tucker on behalf of Ms. Thomas in cases ending in 0996 and 1140, I believe.
I believe we have all the rest, Judge.
Pardon?
I believe we have all the rest.
All right. Your name?
My name is Kiwana Quay Cynthia Rose Thomas. Good morning, Your Honor.
All right.
I believe it's a date and time for citizen, Your Honor, on all files. We have reviewed the report with our client, and I believe we're prepared to move forward.
All right.
And we ask,
Go ahead.
we ask that the court follows the recommendation. Ms. Thomas indicates that she is close to leaving for treatment, so hopefully that will be of help to her.
All right. Thomas, anything you want to say to me before I set James?
No.
No, you don't have to, but if you want to say something to me,
Take it easy on me.
take it easy on you. I don't know if I can do that. No, I'm kidding. All right. On the case ending in 0489, sentence of the court, $125 statutory fees, 365 days in jail, credit 152 served. Defendant to serve the balance. I will allow early release to inpatient treatment. In the case ending in 1140. Sentence of the court, $125 statutory fees, 365 days in jail, credit 152 days. Defendant to serve the balance. I will allow early release to inpatient treatment. In the case ending in 0224, it is the sentence of the court. $125 statutory fees, $88.06 restitution to Meyer, payable through the court. That will be payable. I'm going to make it 90 days after release from jail. And then I'll order 365 days in jail, credit 153 days served. Defendant to serve the balance. I will allow early release to treatment. On the case ending in 0996, sentence of the court, $125 statutory fees, 153 days in jail, credit 153 served. On the case ending in 1569, sentence of the court, $125 statutory fees, 90 days in jail, credit 90 served. In the case ending in 0644, it's a sentence of the court, $125 statutory fee, 365 days in jail, credit 148 days served. Defendant to serve the balance. I will allow early release to inpatient treatment. In the case ending in 0153, $125 statutory fee, 148 days in jail, a credit 148 served. In the case ending in 0482, it is the sentence of the court, $125 statutory fee, 148 days in jail, credit 148 served. I think that is. Thomas, was that easy enough?
Yeah. Yes, thank you.
You're welcome. And when you get released to treatment, good luck to you, ma'am.
Thank you so much.
All right. You take care.
Thank you, Your Honor.
Thank you.
By the end of this courtroom session, several powerful lessons emerge about how the justice system actually works. In one case, a missing procedural step delayed a judgment. In another, questions about possession complicated a landlord-tenant dispute. And in yet another, the court worked to balance unpaid rent with the possibility of financial recovery. What ties all of these moments together is one core principle. Court decisions aren't based on emotion. They're based on documented procedure and legal rules. Even when the situation feels obvious, the court still has to follow the process. Now, we want to hear from you. Which moment in this courtroom surprised you the most? Let us know in the comments below. And if you enjoy real courtroom breakdowns like this, make sure to like the video, share it with someone who finds legal drama fascinating, and subscribe to the channel for more unbelievable moments from inside the courtroom.
Court calls the case of the People versus Tim Pham.
Amelia Garman on behalf of Miss Pham, P number 88377.
Your name, ma'am?
Kim Pham, Your Honor.
All right. Go ahead, Counsel.
I have reviewed the PSI with my client. I don't believe there are any factual corrections at this point other than one date that I did discuss with the probation officer at this time. However, I do take some issues with the recommendation that I'd like to address during allocution.
All right. Go ahead.
Thank you, Your Honor. My client, Miss Pham, is an upstanding citizen. She does work full-time at the Slurping Turtle and otherwise just stays home and helps out with her mother at home. I believe that the 6-month probation is a little excessive, specifically in regards to the no alcohol and recreational marijuana terms. Ms. Pham has no criminal history whatsoever. There were no allegations of any drug or alcohol use during this incident, and she has no substance abuse history. At this point, the recommendation, to me at least, seems overly broad and not really tailored to my client, so I would just ask that those terms not be part of the probation. Thank you.
Ma'am, is there anything you'd like to say before I impose that?
No, Your Honor.
All right. According to looking at it in court, it's pretty much for this court a standard sentence regarding particularly a weapons charge rather than to incarcerate somebody for having a possession of a weapon in a motor vehicle when they're not permitted to. So I'm going to follow the recommendation of probation. I replace defendant on 6 months probationary term. $455 fines and costs, $180 probation oversight fees. When can you get that paid, ma'am?
How much time do you need? Like 1/3 every month. 3 months, Your Honor.
You need 3 months to get, do you have anything today?
Yes, Your Honor.
Okay, so how much do we have today?
$200 for it.
You have 200 today. All right, pay $200 today, and then you need 3 months, I think, to get the rest of it paid.
Well, I've had a recent incident with my car, so
Pardon?
I've had a recent incident with my car, so financially I'm a little bit wrecked right now.
What happened to your car?
I had to pay like $3,000 in repair last month. Yes, Your Honor, I'm in
Oh
the
my-
same boat.
Oh my God, what kind of car?
It's a 2002 Toyota.
See, you should have bought a Ford. Wouldn't have had this problem.
Yeah.
I'm just saying. All right. So you need time to get this.
Yes, Your Honor.
That's fine. I'm sorry to hear about your car.
It's okay, Your Honor. I appreciate that.
Pretty almost good. That would take us to the end of May. When I do this, get the balance paid by June 30th.
Yes, Your Honor.
All right, 2026. There should be no use of alcohol, recreational marijuana, or any illegal substance. You'll be subject to arrest. Jeez, I mean, bless you. Wow. No, you good? Everything's still intact? All right, good enough. Wow. Scared me. There should be random testing as requested by probation. You're to complete a gun safety class as directed by probation. You're not to possess any weapon, firearm, ammunition, or anything fashioned to be a weapon. I will order forfeiture of the Taurus Curve 380 with the serial number as indicated in the file. I'll order 90 days in jail. Credit to the balance is suspended. Thank you. Court calls the case of People versus Kimberly Douglas.
I am the judge. Not him.
Did she steal a pen?
She did not cheat.
Okay, I'm just asking. Just trying to figure out what's going on around here. Right. Okay.
Ron Brown appearing on behalf of Ms. Douglas on both matters.
Mr. Douglas?
Thank you.
I've shared the recommendation. We don't have any changes at this time. She did give a letter.
No, I want to give it to, if you can give it to my lawyer.
Oh, she has, I'm the mailman. I
I'm
gotta
sorry.
deliver this to another attorney in the office. It's
I asked
it's
him
not
to
for
call
you.
me, but I already gave him one.
So I'm the mailman.
Yeah, my letter.
I'll be happy.
Mailman, listen to you. All right. Is there anything either of you'd like to say before I impose that?
No, Your
Ma'am? Any?
No, just that I wish I would have paid these court costs and fines before.
All right. On the case.
Not done what I done.
Okay. You're okay. And the case ending in 1095, $125 statutory fees, $150 restitution to CBS payable through the court. I'll make that due 90 days after release. I'll order 93 days in jail, credit 47. The balance is suspended, or the balance, defendant is to serve. On the case ending in 1776. Sentence of the court, $125 statutory fee, 93 days in jail, credit 47. Defendant to serve the balance.
Thank you.
Thank you. Good luck to you.
Thank you.
Your Honor, spreadsheet, did she have a warrant?
He does.
Did you want to arraign her?
Not really, but I will.
Well, I'm just
Ask
asking.
a warrant. No, that's okay. Yeah, it's a felony warrant. Okay, Ms. Thomas, Ms. Douglas, excuse me. You are before the court on a felony complaint that alleges that on or about January 20th, 2026, the location of Packard Road near Platte Road in Ann Arbor City, Washtenaw County, State of Michigan, that you did possess a controlled substance less than 25 grams, that being a mixture or substance containing cocaine. You understand what that charge is, ma'am? All right. That is a felony. It is punishable by up to 4 years incarceration, a $25,000 fine plus court costs. You understand that?
Yes.
All right. First question I have for you is, do you want to be represented by an attorney?
Yes.
This is a public defender case.
Ron Brown appearing on behalf of Kimberly Douglas, waive reading, stand mute, request PCC in the matter, and please set a bond.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. PCC will be set for March 12th, 2026 at 9 a.m. As to bond,
Your Honor, I'm requesting the bond so that she's getting credit towards this case. She has a release date. I think she told me in
We
August,
set it for August 24th.
August 24th, that she has a release.
it'll be a minute.
We're asking for credit.
So I'll set her bond at a $5,000 10% bond. I'll order standard conditions, including no assault to behavior or possession of any weapons. There should be no use of alcohol, recreational marijuana, or any illegal drugs. I will indicate that you would go on testing of one time per week if you are once released through community correctional. All right. Thank you.
Thank you. I probably told you about that.
Court does call the case People versus Tabitha O'Carroll. Right here.
Good afternoon, Your Honor. J. Grant Miller, P58658 on behalf of Miss O'Carroll.
Your name?
Ateptha O'Carroll.
Your Honor, there was an issue. I was texting the phone numbers for probation to Miss O'Carroll, and apparently those phones kept getting shut off for non-payment. She has contacted probation. She was provided a couple other dates she could go in to do the interview and was informed to go to fill out the forms before she leaves today, and I was planning on going to do that with her, Your Honor. She also needs some time to raise the $75 she needs to pay for the assessment, if possible, please.
And Teresa Claire on behalf of probation, Your Honor, if Ms. O'Carroll would like to hang around today, I could complete the appointment with her this afternoon after I'm done with work.
And I prepared Miss O'Carroll to spend the afternoon here, so I think she'd be more than willing to.
So I don't need the PSI appointment that you set here.
Correct.
In 6 days. All right.
Because there is an issue I with her phone being on.
So let me just go ahead.
I'll do it today.
Okay.
If it's more of a convenience to Miss O'Carroll, and then the appointment gets done, and then we can proceed with sentencing. We could actually do March 11th, Your Honor, if the court wanted to get the case rolling.
All right. And ma'am, your phone's got shut off. Is that?
Yeah, I didn't have money to pay him.
I am in connection
I
with
got
my
you.
client.
Okay.
Mother.
Please. We refer to defendant to probation for a pre-sentence investigation and report.